Yes. Thank you. Right. Thank you. Good morning, everyone, and welcome to the hearing today to continue the process of hearing submissions to the proposed Gore District Plan. And today we're considering submissions lodged to the Ecosystems and Indigenous Biodiversity chapter of the plan. So the panel we have today is myself, Keith Ovell, to my left, Cliff Bolger, far right, Maria Bartlett, and to my right, Glenys Dixon. We've read all the pre-circulated material in preparing for today, so we don't need that read, but we do need a brief introduction dealing with issues, and I'll come back to that in a moment. In terms of the proceedings today, we're going to hear from the advisors of the hearing panel first, briefly from Matt Heal to just give us a little bit of context. Then I gather from Andrew Wells, ecologist, Natalie Hempston, economist. Then we'll go through the bulk of the questions to Matt Heal, and finally discussions with Shelley Chadwick over some legal issues. And that'll take us through till lunchtime. After lunch, we've got Stony Creek with Claire Perkins and Glenn Davis at 1 o'clock, Montwood Station with Coral McLeod at 3:15, Department of Conservation at 3:45, and we've also got some questions for them on the natural character chapter. Then we'll come back tomorrow for Forest and Bird, Transpower and Federated Farmers. So just a reminder to everyone, the hearing is streaming live on the Council's Facebook page and is available for viewing at any time. And when the panel's deliberating, we review that from time to time. The volume of reports and evidence we've received for this hearing far exceeds that for previous hearings. Arising from that and the reversal of view from the expert advisors and recently released supplementary evidence has left the panel with some uncertainty, and it's important from this morning's presentations that we achieve clarity. I want to also flag an issue from the Section 42A report, where it's recommended that certain activities be permitted if the Council is able to provide funding to enable ecological assessments to be undertaken of properties. We do not have the authority to commit the Council financially, and given the focus of the Council on minimising non-essential spending, I believe that option of a permitted activity is not available, so we need to consider the alternatives. For the new people to the room, health and safety, toilets are in the corridor behind. If for any reason the alarms go off, the meeting place is on the footpath outside the council building. So are there any questions or introductions we need to do before we start?
Shelley, just wondering if there's anything you want to cover off before I launch in?
I did just have a couple of minor matters. Good morning, everybody. Apologies for not being there in person. Not well enough to travel yesterday, but many thanks to the hearing team and the panel for accommodating me online. The procedural matters I wanted to address briefly, if I could. First of all, just to note that I'll file a memorandum later today in relation to the wrap-up hearing, so just letting you know that will be coming around lunchtime. In terms of the item tomorrow involving fed farmers, just a reminder that some of that will address the natural character topic for the reason that fed farmers was unable to attend the hearing, not last week, the week before. We received legal submissions from Federated Farmers and new evidence on that topic on Friday. So while I may be able to speak on those topics, I may need to file a written summary of those comments later this week. Turning then to this topic, I have not filed any legal submissions for the hearing today, as on my review of the evidence I didn't identify any legal aspects for which you had not already received submissions from me, including, for example, our previous discussion around the not needing to refer to existing use rights and rules or elsewhere in the plan, as that's already provided for sufficiently in the Act. What I anticipate instead is that the panel's determination on this topic will fall to be predominantly decisions on evidence, including in relation to ecology, the ecology evidence of Mr. Wells and Mr. Davis, who I would note have both recently visited and specifically assessed key sites in preparation for this particular process. While I'm ready to answer any questions that you might have as we go, I'd otherwise now hand it to Mr. Hill to continue.
Thank you, Shelley. Yes, we will have some questions of you after we've asked probably Matt similar sorts of questions, so it'll be fairly obvious where our thinking's at. And probably the other point I didn't mention, I note that we've got Claire in the room, so welcome. This afternoon we would like to have some talkies on site visits. So just to flag that now, I think it's important from the panel's understanding that we actually physically get out and have a look what some of these maps translate into on the ground. So Matt, back to you.
Thank you. I've got a couple of handouts that I just want to hand around. One I have drafted, which is me trying to summarise the very complex National Policy Statement on Indigenous Biodiversity and how it relates to, in particular, Eco Rule 1, so the clearance standards that we've established. It's also got a bit of background about the purpose of the Act and some of the key objectives from the NPSIB. So nothing new, just arranged in a slightly user-friendly way. And Mr. Wells has also provided a brief memo about the extent of or the potential for fencing requirements in areas outside Hokonui Hills. So he's done some analysis on areas outside Hokonui Hills, which I think might be useful. So just wondering if the panel's happy for those documents to go online, so other submitters have access to those.
They've been presented, so they're now public record, so it's quite appropriate for them to go online.
Thank you.
Now, when you say simplify, I guess the way planners use that is slightly different to many lay people. So I see that we've got charts with colours on it, which are difficult to read.
Sure.
One, because of size, and two, because of the dark colours that are used. So when they are online, if yeah, it may be easier to bring it up on the computer.
Okay, sure. So I was just going to give you a quick overview, and so I was going to refer to this big document, 42A report, briefly, as well as my supplementary evidence. And so I'll be referring to various paragraphs of those documents, so as well as the handout I've just provided. So if we, there's also a few errors I just want to identify. So if we're looking at this 42A report, and we go to page 9, and the bottom of that page has got a footnote 4, which doesn't have anything. So that footnote is actually the same as footnote 2, which is on page 8, which just explains what a SEVA and an EVA, SIVA and IVA is. So that's just one thing I picked up. There may well be other errors in the report, but we can cover those off as we go through. And the other thing I just wanted to highlight is in the supplementary evidence, so that's Appendix 1, which is of the supplementary evidence, not the 42A report. And on page, I think it's 14, you'll see there in the green text under Eco Rule 2, there's Appendix XX in brackets, and that's referring to the species list that Mr. Wells has in his evidence at paragraph 38, and Andrew, I think you can just read out that species list for the panel, just for them to understand what I'm referring to there. I think that might be useful.
Yeah, so this is a list of 1, 2, 3, 4, 5, 6, 7 at-risk or threatened woody species found in the Hokonui Hills. So they are Caprosma rubra, Caprosma wallii, Illyria fragrantissima, Illyria hectorii, Illyria lineata, Illyria odorata, and Pseudopanax ferox.
And I have some concern because I have all of them in my backyard, and went to some lengths to actually get the Illyrias, which are difficult to come by.
They are indeed. Not too many nurseries actually carry them.
And the other thing, just referring again to that Appendix 1, if you look at, I've missed a few references to SIVA, Significant Indigenous Vegetation Areas, in the policies, so I'd bracketed them with SNA. And so, in particular, Eco Policy 7.3, which is on page 7 of my supplementary Appendix 1. So it says, 3 says promoting the creation of connections and ecological corridors between significant natural areas. That should be /SIVAs.
My one has the backslash and the SIVA.
Oh,
On page 7.
oh yeah, 3. You
Yeah.
might be reading B.
Yeah.
So Eco P7, 3.
Yes. Yeah, B has it, but 7, number 3 doesn't. And
Yeah.
one of the things we need to discuss is really the whole way that those things are used together, and whether there isn't an easier format to adopt.
Sure. Sorry, and the other one is Eco P10.8.
Which page?
Oh, hold on, that's not right. Oh, sorry. Eco P4, 5 and 6. P4 is on page 5. And you'll see number 5 and 6 just say SNA and not SIVA. So that's Eco P4, 5 and 6. So you also see in the, or you might recall, that I had accepted the definition of pest in my supplementary evidence, and so we just need to make sure that wording is consistent between the rules and the policies. So I can talk about that when we talk about that in more detail. So those are the errors. So happy to move on to give you a bit of an overview. So if we have a quick look at, we're now looking at the 42A report, paragraph 3, which is on page 8. And here I'm just explaining that in considering the provisions, we need to be cognizant of the requirements of the Resource Management Act, in particular the purpose of the Act, and we need to be giving effect to national and regional direction. And overall, the plan achieves RMA obligations by maintaining Indigenous biological or biodiversity, which is a Section 31 requirement under the Act, and protecting areas of significant indigenous vegetation and significant habitats of indigenous fauna, which I've phrased SNAs and SEVAs. So if we turn now to the handout that I've just given you, this colourful one, and we go to page 3, you'll see that I have copied in the purpose of the Act and section 6 and section 31 of the Act. And in particular, if you look at section 6C, which governs this chapter effectively, it's about the protection of areas of significant indigenous vegetation and significant habitats of indigenous fauna. So that's different to, say, outstanding natural landscapes in B. There's no qualifier, which is about from inappropriate subdivision, use and development. There's an outright requirement to protect SEVA and SNAs in effect. However, this needs to be read in conjunction with the purpose of the Act, which is also about providing for people's social and economic well-being. So we need to protect these areas, but we also need to look at ensuring we're accommodating people's social and economic well-being. On the right-hand side, I have copied in the objectives of the NPSIB, and a key focus there in A is maintaining indigenous biodiversity so that there is at least no overall loss in indigenous biodiversity. Okay, so that's a key point. So when we're thinking about rules, we need to protect SNAs and SEVAs, but we also need to be achieving no net loss, in effect, of indigenous biodiversity. But again, if you look at B2, we need to recognise people and communities as stewards of indigenous biodiversity. 3, we need to achieve overall maintenance of indigenous biodiversity. And 4, again, we need to provide for social and economic cultural well-being of people and communities. So we need to try and balance these things together. The other thing I've got down on the bottom right is an excerpt from the Section 32 analysis, which outlines that down the bottom, land use change data and mapping suggests that there are other SNAs in the district. This is because at the moment in the operative district plan there's only 2 SNAs and they're on public land. So this efficiency and effectiveness review looked at how efficient and effective the operative plan is, and it said it's not particularly effective and efficient because we haven't identified these SNAs on private land. And the land use, we did some analysis of mapping information, and that shows that land use change data and mapping suggests that there are other SNAs in the district, and a reduction in overall indigenous vegetation has occurred across the district. Okay, so the rules that we have at the moment, which have no protection of SNAs on private land, haven't been particularly effective at achieving the purpose of the Act or the purpose of the National Policy Statement.
Just before you leave that page,
Sure.
in looking at the NPSIB, the thrust is maintaining Indigenous biodiversity with no overall loss, and to achieve that while looking after the well-being. Whereas Section 5 of the Act says look after the well-being first while looking at the environmental and other bottom lines, which is a 180 turn. And the NPS does that actually because it's followed, which dominates?
So the NPSIB is meant to be delivering on the purpose and principles of the Act, and it attempts to do that by balancing those two conflicting issues. The purpose of the Act is broader than just people's social and economic well-being. It's also about sustainable management, and there's some riders there, A, B and C, and if you look at section 6, it talks about in achieving the purpose of the Act, we need to effectively protect these matters of national importance. And so
But in terms of the MPS, the bottom line is still there is no overall loss.
that's correct.
And so is that the driver that we should be focusing on?
Yes, I think so.
Okay.
So if you just...
Actually, before you move off
sorry.
that page, I just want to explore that a little bit further. So, you use that term balance between the social, economic and cultural well-being and maintaining no overall loss in Indigenous biodiversity. Isn't this the heart of king salmon and the way we should think about that while in section 5, and also the instruction to protect in section 6C? Yeah, so
Yes.
you're nodding. Yeah. So there's no trading off involved in terms of the balance. It's there is an imperative to protect areas of significant Indigenous vegetation and significant habitats. And so what you've just explained is that the NPSIB is delivering, it's the delivery vehicle for achieving section 6C. And when we go across and we've got A with that maintenance and the no overall loss, and so we can think about 1A, can we, as being akin to protecting under section 6C by maintaining,
Yes.
we're protecting.
Yes, I thought the other thing to note is that, sorry, at the bottom of the RMA column, we've got section 31, which is about the maintenance of Indigenous biological diversity, so which is a function of council in developing the plan.
Yep.
So not only do we need to protect
Yep.
SEVA in significant natural areas, we also need to maintain Indigenous biological diversity.
Yep.
And so the NPSIB is trying to achieve those two outcomes.
Yep.
Subject to the directions that are given in the RPS, in particular, that the Regional Council is responsible for wetlands and rivers.
That's correct. So,
And just before you move off again, so then when we look at the objective, the NPSIB objective 1B3, it's added the notion of restoring, so not just protection as per section 6C, but it's suggesting that sometimes to achieve the overall maintenance and no overall loss, so that maintenance in section 31 1B3, sometimes restoration is necessary to
that's
accomplish
correct.
the
And
aim.
I think, having reviewed the evidence from the ecologists, I think a lot of what we're going to be discussing turns on how people interpret no net loss of Indigenous biodiversity, because some of the ecologists have suggested that you can have some loss of vegetation and still achieve that outcome, whereas others have taken a slightly stricter view, I would say. And so I think that's probably one of the key things to focus on through this hearing.
And is that, though, when I was reading some of the ecological evidence that was suggesting you might be able to nibble, that was dependent upon other areas of regeneration that were being looked after, so that the only way you could have the nibble was if you also had the regenerating areas. And I guess that's an ecological.
I think
that's a question for the ecologist.
Yeah.
But I guess I was thinking that it absolutely relies on expert
Yes.
assessment. Yeah.
So,
Can I jump in as well? Just because we're talking about words. The way I've thought about no net loss is to think about that line that shifts up and down a little bit to accommodate the improvements of the areas that are protected as that boon or that benefit you're gaining as a result of the additional protections over the quality areas, and then the small amounts of loss of the boundary areas, for example, along the fence lines and things. So no net loss is how I've thought about that, Commissioner.
I think the other thing to bear in mind, Indigenous biodiversity doesn't equal Indigenous vegetation. So, you can lose some vegetation and still achieve overall biodiversity improvement, because biodiversity also includes things that inhabit the vegetation. So just carrying on to the last page of that handout, this is an excerpt from the Efficiency and Effectiveness Review, and this is what the Section 32 analysis was referring to. And here you can see mainly focusing on the text in the middle of both slides. Basically what we did was we looked at land use mapping, which identifies different types of vegetation types, and what it's showing is that both Indigenous and exotic shrub land are decreasing, and that there hasn't been a lot of change in terms of Indigenous forest and tussock grassland, but there has been a reduction in Manuka and Kanuka, which is about 70 hectares, Matagauri about 80 hectares, and deciduous hardwoods about 6 hectares over the period between 2008 and 2018, which is roughly the period of the operative district plan. So I guess what I'm saying there is the operative district plan has no controls over Indigenous vegetation, and as a result there's been some loss of Indigenous vegetation over the life of that district plan. So doing nothing isn't achieving the outcome of no net loss based on that data.
So Matt, I just question, because I know this is to 2018. I mean, personally, I've seen a lot of loss of grasslands and tussock lands since then, with dairying coming into the province. So I would suggest that these figures possibly are worse than what's showing on here.
Yeah, so the data comes from a national database, and the report, they inform the 2022 effectiveness and efficiency review. So that was the data that was available at the time. I haven't had an opportunity to look at the data since then, but I guess the key point is it's showing a downward trend.
And I was confused by the headings. Column 3, I've worked out, should read 2012 hectares.
Right, yeah.
And further along, it's 1996, not 21,000 and
Yes.
whatever.
So I thought I'd just give you that overview and then talk about the colourful slides on the top, because that provides a bit of context. So what I've done here on, if we go to the first page, the column on the left are relevant clauses from the National Policy Statement on Indigenous Biodiversity, and the column on the right are the corresponding parts of Eco Rule 1. So Eco Rule 1 is basically outlining the activities and the extent of vegetation clearance that's appropriate. And what I'm highlighting here is that a lot of those activities that are identified in the plan come directly from the NPSIB. So for example, if you look on the left-hand column, 3.10.5 is all about covenants. And so in Eco Rule 1, highlighted in yellow on the right-hand column, we make provision for biodiversity covenants in the permitted activity category. And so that's how this table works, basically follow the colour code. And so again, if you look at the green under 3.10.6a on the left-hand column, it's basically saying we need to provide for any use of development required to address high risk to public health and safety. And so as a consequence of that, on the right-hand column in the Eco Rule 1, we allow for vegetation clearance where that vegetation is causing an imminent danger to human life, structures and infrastructure, etc. So that's what I'm trying to show in this table, that actually a lot of the provisions in Eco Rule 1 come directly from the NPSIB. Okay. And so if you turn over the page.
Sorry, just before you move on from there, can you explain how Indigenous biodiversity could cause issues with safety and public health and safety, apart from huge trees falling over?
Yeah, so that's it principally, trees falling over. So it might be, you know, if you've got a house and there's a significant natural area right next door, and there's a big tree that's dangerous because it's beyond its life, then you would be able to remove that tree on the basis that an ecologist confirms that it's beyond its life.
So you would need consent to do that?
No, it's a permitted activity. So the NPSIB says, if you look at clause 3.10 in the NPSIB, it says generally we need to manage adverse effects on SNAs of new subdivision use and development, but then you get down to clause 6 of the NPSIB and it says nothing in this clause applies to adverse effects on an SNA from any of the following: any development required to address high risk to public health and safety. And so I've equated that to being a permitted activity, which is why that's referenced in Eco Rule 1, because in effect the NPSIB says we have to disregard the effects of these activities. Okay?
Okay.
So that's how Eco Rule 1 was built.
So can I just, while we're there, in looking, it's really helpful the way you've done this. When I look at the NPSIB 3.21 and that restorative element, and then I look across at what's there, I can see that removing exotic species and pest plants, etc., is definitely a restorative action. But I did wonder around, you know, land disturbance that might be required as part of a bigger restoration project or something
Yeah,
like that.
so there's a bit of a
Crossover with the earthworks rules and
there's a bit of an
landscape
issue
and
with that rule and the way it's framed. I think Ms Perkins drew my attention to this at one point. So if we pick up Appendix 1, again, we go to Eco Rule 1, which is on page 11 and 12. So if we start there, it actually starts on page 10. So this rule is about Indigenous vegetation clearance and land disturbance. And that's permitted where, and you've got a whole lot of activities there, and you get down to, where is the one about? H. Yeah. So it's basically saying that you can remove indigenous vegetation if it's where it's for the removal of exotic species. That's not the point, okay? The point is you should be able to remove exotic species and pest and weed plants within those areas, okay? And so potentially this should be a standalone rule that says it's a permitted activity to remove exotic species and pest plants and pest animals within a SEVA or EVA, in fact.
Would that same rule also address the other limb that I was suggesting might be missing? Or is that other limb sort of dealt with in other parts of the plan in terms of this idea of land disturbance to assist in restorative activity that isn't clearance of exotics? And is that more in the earthworks category or NFL category?
Yeah, and you're right, you've got to throw in the natural features and landscape category as well, because I think this is where the document at present's a bit weak in terms of which dominates and how do they fit together. And there was a reference in the natural features and landscape to the rules that are in this chapter, but there's not one back again. So we'll be looking to you for some advice in terms of the way we do it. But back to Commissioner Bartlett's question as well in terms of earthworks. That rule, and I'd picked up on, and obviously she has too, that rule appears to authorise doing earthworks without any controls in the removal of this indigenous vegetation.
That's correct, and so that's what I'm saying. I think that the rule's broken. It needs its own standalone rule in this chapter.
And probably subject to the earthworks chapter.
Well, I guess in my mind, if you're controlling land disturbance, you're likely to be controlling earthworks anyway, because land disturbance is, there's not a lot you can do under land disturbance, whereas earthworks is more permissive, if you like.
So this is where I think like land disturbance is part of the earthworks definition. That's something that was canvassed in the earthworks hearing, so it's possible that this rule might need to limit itself to indigenous vegetation clearance or vegetation clearance, and that might sort of just deal away with that confusion. Yeah.
So when you look at the policy is all about enabling the removal of exotic and weed and pest species. It's not about clearing indigenous vegetation to achieve that. So for example, it doesn't anticipate bowling a whole lot of significant natural area to get into an area to get rid of weeds and pests. It's just about enabling the ability for people to take weeds and pests out, because otherwise if there's no permitted standard, it'll kick to non-complying, for example. So yeah, if I can just turn over the page, so this is the second page on the handout. And I've done a similar exercise here. So you'll see 3.14 at the top relates to plantation forestry activities, which are actually now commercial forestry activities given the change of the NES. And you'll see on the right hand column the indigenous vegetation is grown within the area of commercial forestry and is located outside an SNA or SEVA. So that's effectively giving effect to the NPSIB. So a lot of these standards that are in Eco Rule 1 come directly from the NPSIB. I think the gnarly bit, or where there's a bit of debate, is around Eco Rule 1.1, which sets limits around things like clearance associated with fences and vehicle tracks and roads, etc. So the MPSIB on the left-hand side, under 315, says we need to manage adverse effects of established activities on SNAs. However, for the purpose of this clause, established activities means any activity, including maintenance, operation and upgrade, that is in or affects an SNA and is not a new subdivision use and development. In my mind, that means that you can continue to undertake existing activities, not new activities. And that's why Rule 1.1 is about the maintenance, repair, replacement or upgrade of existing lawfully established activities listed below. And the activities listed below kind of come to that issue we were talking about before, and the need to balance no net loss in effect. And so with people being able to ensure their social and economic well-being. And so the list here, things like fences and fire breaks and walkways are activities that you might anticipate on a farm. Some of these things, of dams, for example, waterway crossings. So those are the things that I put in the camp of needing to provide for our social and economic well-being while achieving no net loss. How do you achieve no net loss? You have to set a limit on those things. So you can't have unlimited clearance for fences, etc., because otherwise you run the risk of not achieving that no net loss target. So that's kind of a very quick overview of how the Eco Rule 1 delivers on the provisions of the MPSIB and the RMA.
Can you just hold for one moment? That page also explains where the phrase of new subdivision comes from, that appears in the rule. And I kept thinking to myself, well, what is new subdivision? There's an old subdivision one that happened years ago, and you compared to that, and the drafting is actually quite poor of that section, because you've got new subdivision, comma, and therefore the use and development is it new use and development. So the way that it would have made sense to have said subdivision, new use or development. And in the plan provisions, do we even need the word new? We don't have to follow what's in the National Policy Statement to the letter, and it just, in the context of the district plan, having the word new there just doesn't make sense.
I think, to be fair, I don't know how you've found it as a panel, but the MPSIB is very difficult to interpret, and I think that's potentially part of the tension between some of the submitters, because some things are a bit open for interpretation.
And I was going to ask, is there any case law in the way that the National Policy Statement is actually worded, particularly when you come to words like high risk?
Before we move off this page, I just wanted to talk through 3.142 of the MPSIB, which is the plantation forestry, and which you've mapped onto Eco R1L, but the key difference that I can see between the two is that in the highlighted blue for the MPSIB bit, it's talking about an SNA that's within an area of existing plantation forest. But when I come down, it's indigenous vegetation within an area of commercial forestry, so I'm guessing that must be existing, because it's existing in 3.142, but it's not specified in Eco R1. But then is located outside SNAs and SEVAs. Now, is that because, and so that's quite a big difference between the way the two are working. One's talking about SNAs within a forestry area, and one's talking about Indigenous vegetation in a commercial forestry area, but outside an SNA or SEVA. So they're doing different things, is I guess the alert.
So I think from memory, 314 is about it's controlling what you can do in any part of an SNA, right? Which suggests that you need a consent pathway if you're in an SNA. Eco Rule 1 is about permitted activities, so it's consistent with the NPSIB because the NPSIB is directing you to look at the effects when you're in an SNA. The permitted standard is saying you can clear Indigenous vegetation if you're outside an SNA, so those two things are consistent in my mind.
Just another question, Matt. If you've got an existing vehicle track or farm track and you're allowing 1 metre each side of that farm track, how do you not take out any net loss to the biodiversity?
I think that might be a question for the ecologists. Well, I'm sure we're going to get into this discussion because there's a divergence of views as to whether that's appropriate or not. So, it's probably a better place for the ecologist when we get to that part of the hearing.
I think in your supplementary you talk about 1 metre, but also no greater than the existing width, which I assume is more than 1 metre.
It can be. It depends. Yeah.
Might be less.
Yeah, that's right.
So that would answer your question.
So just continuing on then, I was just going to give you an overview of what's been recommended in the 42A report and then what's been recommended in the supplementary. So if we just turn, if you've got the 42A report, and we're looking at page 10, paragraph 10, which is highlighting what I have recommended in terms of the original 42A report. Probably take a lot of this largely as read, but just wanted to point out a couple of things, in particular D, where removing Eco P8 and P9 because they largely duplicate the provisions in other policies. Moving down to E, we're deleting P12, which is about managing weeds and pests because this is largely done through the Regional Pest Management Plan. You'll see in F, this is where I was talking about making development in accordance or clearance in accordance with a council approved biodiversity management plan a permitted activity. I discussed this in my supplementary evidence. I'm suggesting we move away from that approach, and this partly comes to Commissioner Havel's matter that he raised at the start about not wanting to commit council to things that haven't been funded. So this clause was new. It wasn't something that was in the plan at notification, so the council hadn't anticipated that this might be happening, and there's a cost associated with that. But I'll talk a bit more about that when I move you to my supplementary. That's probably it in terms of the 42A. So if we now go to the recommendations in the supplementary evidence, which is on page, this is my supplementary evidence on the 20th of February. We move to page 3, paragraph 11. So what I've done here is I've gone through the evidence by submitter and just highlighted where the key changes are. Or so if you look at paragraph 11, in relation to Southland Federated Farmers, I'm not recommending any changes to Eco Objective 4 regarding mahinga kai. B, however, I am amending the policy from enhancing mahinga kai to enabling mahinga kai, and that's largely because the rule allows for a range of cultural activities, including mahinga kai. So the rule enables it, it doesn't seek enhancement of mahinga kai. C, new definitions of animal, pest, fire break, vehicle track, dam and walkway. So I've recommended that those be accepted. D, amending Eco Rule 1 to clarify the width of clearance for fences is no greater than originally cleared. Now, Mr. Wells has handed out his memo that came today, which is effectively analysis of the sites that have been surveyed outside the Hokonui Hills. And what that indicates is that from that analysis that fencing tends to be on the edge of those SNAs, not through them. And so when we get to that evidence, we might want to have a think about how that rule is framed, that change to Eco Rule 1. E, reference to farm tracks as well as vehicle tracks, so provision for clearance associated with vehicle tracks. And F, the addition of Indigenous vegetation clearance where that vegetation was deliberately planted around the margins of existing dams. So that's my recommendations in relation to Southland Federated Farmers. Moving now to paragraph 12, which is the Department of Conservation. So we've talked about the removal of council-approved biodiversity management plans. And that's largely because I don't believe the council has the capability or the capacity to implement this. There's a lack of in-house resources and funding to make that successful. If I think back, I used to manage the consents team and the policy team in Waitakere up in Auckland, which is the Waitakere Rangers, effectively. Quite a different environment because they had 90 to 100% coverage of Indigenous vegetation. But they had an in-house team of 3 ecologists and the resource consents and compliance team and 3 ecologists and the policy team. So if you're going to take an approach where you're promoting this sort of approach, you really need to resource it. Similarly, when I was managing the policy team in Nelson, which is a bit more similar to this area in terms of, I think they've got about 100 significant natural areas. They still had 2 in-house ecologists, and they ran an exercise of going out and doing council paid for mapping of these areas, giving advice about weed and pest control and that sort of thing. So I think the council approved biodiversity management plan approach might work if you had the resources to support it, but there's no indication that that's the case here.
Nelson's a unitary authority, isn't it?
That's right, yep. So they have,
yep.
They also have the functions of Environment Southland. And so Environment Southland at the moment have funding from the government to run a mapping exercise and a weed and pest management control process. So, yep, that's correct.
Is that the funding that's assisted, I read 13 properties to have a free ecological assessment? No. that's something else. And we'll come to that, I guess, yeah.
Okay, so just going to paragraph 12B, just clarifying that plantation forestry should read commercial forestry in accordance with the NES commercial forestry. 12C, recommending to delete the rule that permits vegetation clearance for vegetation no older than 15 years. And that's largely because we've got another rule, which is M, I think, which allows for up to 50 square metres of Indigenous vegetation clearance where it's not captured by the other provisions in the rule.
Is that 50 square metres ground square metres or the canopy of the tree?
I'd have to have a look at the actual wording of the rule. It's Indigenous vegetation clearance for any other activity for existing farming operations covering an area of less than. So I would imagine it is 50 square metres of Indigenous vegetation, where over a 5-year period involving non-forest vegetation. So if it's non-forest, it won't have much of a canopy, I'd imagine. It will? Okay. Yeah, you jump in.
Yeah, so this is how I understood that in terms of it means total area, and if it's non-forest vegetation, that'll be shrubs or tussocks interspersed with areas, you know, of grassland or non-Indigenous. So the intention, as I understood it, was the total area refers to the mix of Indigenous and exotic species which together form an area, rather than measuring around that shrub and that shrub.
No, my question was that are we talking about as measured on the ground level or measured from an area of view where you take out a tree that's of this shape?
Oh, I'm with you. It's a ground.
Right.
And yeah, and
Wouldn't
so,
be a tree.
yeah, because otherwise, yeah, I see what Matt's saying. So the canopy only applies to trees.
And the land disturbance, according to the land.
Yes.
So just point of clarification, so that 50 square metres of clearance is for vegetation no older than 15 years? Is that
No,
what that's relating
no,
to?
No,
That
they're
isn't
two separate
relating.
things where what we're recommending is getting rid of the rule that provides for a blanket clearance of vegetation that's less than 15 years old. And that's largely because of issues around how you actually monitor and enforce that, but also it's unclear how that would achieve no net loss because we don't know the extent of that.
So
ultimately.
that rule, no older than 15 years is out.
That's what I'm recommending,
That's what you're
Yes.
recommending, yeah,
but the 50 square metres is recommended to stay.
to stay in. Thank you.
Are we talking about the same thing? Permitted to clear 50 square metres as opposed to clearing anything that's reverted in the last 15 years. The areas could be vastly different.
Yeah, that's correct. I think the other thing to note, and Andrew might go into this, is, I keep forgetting the term, maintained.
Maintenance of improved pasture.
Maintenance of improved pasture is also provided for within the rule as a permitted activity as well, which would capture some of that younger vegetation.
I would also be able to assist with some comments in terms of the difficulties of enforcing a rule which refers to vegetation that is no more than 15 years, if that would assist. I'm not sure if it's an issue for the panel, but happy to comment on that if required.
I think we understand the difficulties in actually measuring it. Even when I look at my own property, I've got trees that are 3 or 4 metres high, and one's planted at the same time, maybe a metre high, because of different eco-climate.
Clarity again, so you've got improved pasture, but it might be overzoned pasture as opposed to cultivated pasture, and it's got some indigenous biodiversity on there. You've got to work around that. What's the approach that's permitted?
Yeah.
The approach is according to the NPSIB's interpretation of improved pasture and maintenance of improved pasture. So without the NPS in front of me, it basically goes through a list of what defines improved pasture. And so that same definition is what is proposed in this rule. So therefore, if an area is improved pasture, according to that definition, then yes, the indigenous individual plants can be removed.
So where's that definition?
It's in the National Policy Statement for Indigenous Biodiversity.
It's also in the proposed district plan because it just copies it over, in effect.
And Mr Davis's evidence specifically goes through some of that as well. I'm sure he'll add some more comment.
So just carrying on in terms of the Department of Conservation submission over on page 4, they're seeking an amendment to avoid vegetation clearance associated with the margins of the Mataura River, referenced in the Southland Regional Policy Statement. And you'll see in my paragraph 153 in my supplementary evidence, I'm not recommending this. But the option, I've put the option in here if the panel is minded to do this. So the wording of how that might be done is, if you look at paragraph 153 of my supplementary evidence, which is on page near the end, 28. It's a permitted activity where it avoids the margins of the Mataura River outlined in the Southland Regional Policy Statement and is necessary for any of the following purposes. I think we'll get into this discussion as you talk to the ecologists through the course of the hearing. But there's a concern there in that the regional policy statement is a bit vague on what it means by the margins of the Mataura River, and I think the ecologist for Department of Conservation has indicated in his evidence that it's a particular area, but I'm not sure where that is, so I think it'd be useful to tease that out before making a call on whether that addition is appropriate or not.
And so this will have an obvious relationship with our natural character chapter that we have covered in prior hearing, and obviously that other part of section 6 that's concerning itself with the natural character of the margins of water bodies. So part of what we need to do is work out
Where it fits.
how these things are working together.
Yeah, in conjunction with the buildings and structures adjacent to streams and relevant setbacks. And just Eco Rule 2.1, to avoid the loss of threatened or at-risk woody plant species and Hokonui Hills habitat. And so that was added on the advice of Mr. Wells. However, we've also had evidence since then from Stony Creek, I think, supplementary evidence that suggests that this might not be necessary given the provisions of the Wildlife Act, particularly in relation to lizards, but again, this is something that needs to be teased out based on the evidence that's provided by the various ecologists. And then last, paragraph 13, that's really just those changes relating to TransPower's evidence they're principally seeking alignment with the National Policy Statement, electricity transmission. So it's a very quick, maybe not so quick, but an overview of what I'm recommending in relation to the 42A and subsequently the supplementary evidence.
And even in terms of what you've explained today, there's further recommendations in terms of changes to your Appendix A. And I think it's important by the time we finish tomorrow that we actually have a updated copy that actually shows it clearly. Because you referred to, if the panel is of the mind, maybe this, or given what has been raised on one of them, we need to have this as a separate rule. Given the volume and the different variations that are coming through from all, if we can minimise the number of different versions that we've got and somehow bring it together in a more coherent way would be very helpful to decision writing.
So I think Appendix 1 to my supplementary is the latest version. However, as you say, there may be some changes to that coming out of as a result of the evidence that we're yet to hear. So we can certainly do an update at the end. That may require a minute. Depends how much time we've got at the end and how complex the changes are.
We're already at the high end of complex.
So that's me. I was going to hand over to Natalie, Miss Hampson, and it's Hampson, Hampson.
It's alright, I get
I got that right?
different versions.
So if there's no further questions for me, I'm happy to hand over to Ms Hampson to talk about economic evidence.
Welcome. So it would be good to have a brief overview and in particular, so we're fully understanding in terms of the shift that's occurred in your advice between your initial evidence and supplementary statement.
Certainly. Did you want me to give a brief overview of my evidence in chief? Yes. My evidence in chief starts out with a bit of a discussion around sort of the values and benefits of Indigenous biodiversity, and I think that's really important because it's the reason these regulations exist. These are the benefits that we stand to lose if Indigenous biodiversity continues to decline, and equally, particularly when the regional biodiversity strategy comes out and it encourages more enhancement and restoration, that these are the benefits we can expect to grow in the future. I provide a brief discussion of why the regulation is needed, which is really understanding the problem statement, and that problem statement's not unique to Gore District, it's a national problem, and that's why the NPS was brought into effect. I've carried out a spatial analysis, which I think is really important because to understand the effects of these provisions, we need to understand where they sit on the ground. So that's used a range of data sets, including aerial photographs and GIS data layers, including the CEVAs and EVAs that have been supplied to me from the property group, and just to understand how they overlap with property boundaries. So some of the key findings from that were that in total, all of the CEVAs and EVAs fall into the general rural zone. They fall within 177 private land properties, and there's a few that fall within some obviously DOC or Crown and one or two Maori land properties. The evidence is focused primarily on the general private property, because that's where we sort of hit the ground in terms of property rights. So there's about 77 properties in the district that contain SEVAs, and there's about 68 that comprise some area of EVAs, and there's 115 in total, so there's some that contain both. So overall, that's a very small number of properties in the district that actually are affected by this chapter. Based on that mapping, I think this chapter, it's important to remember it probably does apply to other properties as well. It's just on those particular properties we haven't mapped any specific Indigenous vegetation. Provided a bit of discussion about the economic costs attributable and not attributable to this chapter. So things like when we talk about transaction costs, which are consent-related costs, and compliance costs, which are the rule, some of the conditions that come out of an approved consent. Some of those things, if the consent would have been required perhaps through a subdivision consent or because the activity required a consent in the general rural zone chapter, we just need to remember that some of these costs need to be sort of shared, if you like, across the drivers of those consents. So we've tried to focus on what's actually attributable to these specific rules to get an understanding of what that might mean. And I've talked about some of the costs and benefits that I haven't included because some of those are voluntary costs. They're not prescribed by these rules. They may be expenses that landowners pursue, but they're not, the rules aren't forcing them to spend that money. So those things are excluded. I focus on primarily the rules in the chapter because that's the easiest place to understand those tangible effects of the provisions for landowners. So I focus on Rule 1 and Rule 2, the new Rule 2 for Hokonui Hills. And I did spend a bit of time trying to get to the bottom of or understand the clearance rules around some of these existing activities, so around fences and dams. And the best way that I felt that I could come up with that was to understand or distinguish those into things that you can traverse. A lot of the evidence was around clearance and the mechanical way that you would achieve that, so the machinery you would use. So it was really about providing access for machinery to carry out those tasks. So some of those features like roads and vehicle tracks and walkways I'd describe as traversable because the actual width of the feature itself can provide access for those machines. And then other things which I called non-traversable, which is where the machinery literally has to be down one side or the other. So we don't drive over the top of a fence, we drive down one side of the fence. Same with network utilities, that kind of thing. Same with the dam, we drive the vehicle on one side of the dam, not right through it. So that to me gave just a bit of, a practical lens as to how we might assess the effectiveness of these clearance provisions. So overall I provided an assessment concluding that overall the provisions were efficient, that the benefits probably outweighed the costs, and I did suggest a few amendments to some of those, particularly those clearance rules that I thought might be more practical. And I think the importance of being practical is where we hit the ground with does this allow farmers to carry out their functions, and that's the link between achieving their economic well-being or not. So if we can be as practical as possible within limits, then that's not precluding landowners from providing for their economic well-being. In terms of the supplementary evidence, I responded to two statements. One was the Southland Federated Farmers and briefly the Stony Creek Station planning evidence. In terms of the Federated Farmers, you may have seen I've spent a little bit of time justifying perhaps my qualifications and what's within scope of an economic assessment, and I don't focus on that here. One of the things I did talk about in terms of the Hokonui Hills rule, I guess my experience in carrying out my assessment for this evidence was that the new Rule 2 for the Hokonui Hills just sort of seemed to appear out of nowhere, and I was very much reading that at face value. The same way that perhaps another submitter might have read it, or a member of the public not perhaps understanding where it had come from. I obviously didn't have Mr. Wells' on-the-ground expertise in that process. And I just was concerned that at the time there was the evidence that you would normally expect in a district plan that would justify why that precinct had its own rules just was sort of missing from the evidence base. And I have explained in my supplementary evidence that I feel that, I guess, sort of in a roundabout way, that the evidence process has now filled that gap and has provided the justification for that bespoke rules for the Hokonui Hills properties. And I accept that that now has removed that concern so that it is justified. I also clarify that I guess my focus wasn't on the rules themselves, but more the precedent that it may have set for other landowners. So at face value, they might have thought that the Hokonui Hills properties could have extra clearance rules with no thresholds, that they had a more enabling approach. And I think the risk was, to me, that that might lead other landowners approaching the council and saying, well, I'd like a working group, I'd like my own bespoke rules, and I was just sort of speculating that that might get a little bit out of hand and create some quite significant costs. I feel now that that precedent risk has diminished because the evidence sits there that this precinct is unique and that these rules are appropriate and that it's a different environment from the rest of the district. So I have shifted my position on those concerns. Also talk about the Federated Farmers have identified that I've not included in my estimate of transaction costs that may be faced by landowners requiring a consent, the cost of a cultural impact assessment. I understand that this is perhaps not limited to this chapter, but is perhaps driven by a range of, or the intersection of a few chapters working together. I agreed in my evidence that that's not something I've specifically included in my assessment of transaction costs and that they would be in addition. I do speculate based on the cost provided, if in fact that's reasonable, I'm not sure, that it would increase the costs. But I maintain my conclusions that overall I don't think this is going to prevent farmers from carrying out farming and to be viable in that business. So yeah, no real shift in terms of my conclusions. But yes, there are added costs that perhaps haven't been included. And talk about clearance limits. So there was further evidence provided on that. I think it's just, in my supplementary evidence, I think it's very important that we keep remembering how the number of properties this is actually applying to, and then the practical lens of these activities and whether or not they're actually occurring in locations that will require vegetation clearance in order to maintain, repair, upgrade or replace. So I've talked a little bit about the fact that there hasn't been, whilst there's concerns about the workability of some of these clearance limits, there's been no evidence provided on the sort of the probability that these things will actually play out on these properties. And helpfully Mr. Wells has provided some further evidence today around fencing and where they're actually located in his experience. And I think that's a really important thing to keep in mind. I make a minor point of clarification in my supplementary, just I think there'd been some version control. I had recommended some wording for the clearance thresholds for these non-traversable things like fences. I think that wording didn't translate perhaps as I had recommended into the section 42 and the submitter for Federated Farmers has picked up that earlier wording from the section 42. So I've just clarified my original intent behind that wording. I've provided some further explanation around the reality and the practicality of the fire breaks and the waterway crossing evidence. Same with vehicle and farm tracks, just reiterating that I think that the proposed or recommended clearance thresholds are appropriate. And we've just talked briefly about fences. Again, I think that this is applying in very few situations, and on that basis, the provisions that are recommended are probably still workable and practical. The only final thing in my supplementary evidence, I respond to the evidence of Stony Creek, where Ms. Perkins has pointed out that I had incorrectly referenced or assumed differences between the Hokonui Hills rules and the original rules in R1. And so I would like to confirm that paragraphs 118.5 and 118.7 of my evidence in chief should be just struck out.
So you ready for questions?
I am.
Cliff? No. Glenys? Okay, Maria? I think the way you have responded in your initial evidence and interpreted the very permissive rule that's sitting there is one that is still front of mind for us. And would you expect better clarity if there was actually a specific policy section that dealt with the Hokonui Hills? Because in other areas, such as the rural lifestyle area that adjoins the Hokonui Hills, there's specific policies that apply to it. So would it be more transparent from your point of view if there were some explicit policies as well that applied to the Hokonui Hills?
Well, I think one has been added in response to the introduction of the new Rule 2, which I guess is to make that functional link between a policy and a rule. So I feel that that is there. I think my original concern is that normally a precinct might be added through a proposed district plan process and would have been assessed through the Section 32 and would have sort of been more of a ground up evidence base. But I think it was more that the policy and the rule together seemed to come out of nowhere, in a sense, for me, because I wasn't involved in the process.
It's a part of a policy, and I'm just wondering whether there shouldn't be a standalone policy that deals with a range of matters.
Yeah, I think EcoP 13 is specifically targeted at the Hokonui Hills area, but it's quite broad.
Yeah.
So I guess once the panel lands on the appropriate scale and list of activities, then that policy could be revisited to be a bit more specific.
Okay, back to Natalie. What's your understanding of FENZ's ability to issue directions?
My understanding is only as I've read in the evidence that they can direct a farmer to require, are you referring to the fire breaks? That they can require that and that there is a time frame within which they need to comply with that. Obviously, any fire break is within vegetation, so the clearance of vegetation is a given. I'm comfortable with the fact that it's a restricted discretionary consent, even though that imposes some extra costs on the farmer in terms of transaction costs. It also potentially requires compliance costs, which may mean that if there's a significant effect on an SNA because of that fire break, that there is a compensation or a mitigation function, so that no net loss of biodiversity is imposed on that landowner. I guess whilst that sounds onerous, the benefits of having that fire break are also substantial and could be substantial for that landowner. Again, that FENZ requiring a fire break is not prescribed by the plan. It's an external driver of expenditure, and so I think that needs to be taken into account. It's not necessarily an optional cost.
Although we have rules relating to our trees of significance, that even if the power company issues a notice, it still requires a consent. Now it then comes down to supervised work, I guess is the way of describing it. it might be outside your area of expertise, but would you think there'd be a similar approach to the fire breaks?
I think so, and if there is a consent, obviously it needs to be complied with, and so the council have some oversight as to what was carried out on the land.
Yeah, I'd like to hear from other witnesses later, and just to flag it in terms of what are we talking about in fire breaks, is there controls over how wide they are, etc., and then you're allowed to clear vegetation each side of them as well. So just to flag that for clear it.
It does come back to the fact that if there are fire breaks required, based on what we know, we think that's a maximum of 115 properties, and presumably there are already fire breaks in that vegetation where necessary. So I guess the reason for more fire breaks is, one would need to question why we need more fire breaks if the vegetation has looked the same for quite a long period of time. So I think the incidence of requiring new fire breaks might be fairly rare, in my experience.
How do we balance the transactional costs with the management of adverse environmental effects?
Well, I think the transaction costs are there to achieve the environmental outcomes that are required by the NPS-IB. So I'm not sure I totally understand.
Well, when I compare your initial brief and the supplementary evidence, one of the messages that comes out to me is that where there is a cost to going through resource consents, then that is something that we need to take is an economic impact. But equally, if the rule wasn't there and there was the clearance of vegetation, the adverse environmental effects. So there's a balance almost required between the cost to the landowner and the adverse environmental effect of not having.
And this is the challenge with Indigenous biodiversity, because as I've said out at the beginning of my evidence in chief, the benefits of protecting it are not just to the landowner, but to the entire community and beyond. And so we have and sometimes those benefits are in the future, and yet the costs are in the short term. So there's this real disjunct between costs and benefits over time and on the ground. And so I think it's just about having that, or remembering that the benefits that you're trying to achieve by imposing a resource consent are in fact valid and widespread and will benefit the entire community, as well as the landowner. Those benefits to landowners from having that Indigenous vegetation on their piece of land are also, their material. So, it's important not to lose sight of the benefits that those consents achieve.
So to what degree should we have regard to what is probably something the responsibility of council in terms of rates relief or anything else?
I think the NPS-IB does encourage councils to consider that as a way of perhaps mitigating some of those burdens on landowners that have Indigenous biodiversity. Again, we're talking 115 potentially properties or ratepayers, which is a very small share of the overall ratepayers. But the benefits of what they're doing or what they're required to protect is for all ratepayers.
And aren't we then creating a precedent if council went that way for where you've got significant tree heritage buildings on your site and etc., etc. Are we opening it up for wherever there's a district plan control that doesn't apply to the whole district, that the landowner potentially could be coming to council saying you should be giving me rates relief the same as others?
I agree, there is a risk of that. I think incentives that other councils have used are not necessarily financial. I know some, maybe it's the Rotorua district plan, they might give them some different allowances in terms of subdivision, there may be some other ways that are not necessarily financial that perhaps is appropriate for the rural zone. So I guess it's not an easy thing to work out, and the precedent effect is relevant for council.
Okay, thank you. Maria.
So I just wanted to start, I followed your evidence, it was really clear, it's really helpful. where you're responding in your supplementary evidence at paragraph 6 to the Federated Farmers' evidence around sentiment and community sentiment, I think it goes to what you were just talking about in terms of the benefit proposition, but I did wonder if you'd like to expand more on the origins of your assessment around sentiment, because you've alluded to accepted national and international literature and underpinned with the development of the NPSIB. I just wanted to give you the opportunity to expand on that if you wanted to comment.
Sure. So I was hired by Ministry for the Environment to produce the cost-benefit analysis of the proposed NPSIB, and as part of that project it was also the contract to deliver the Section 32, which was carried out by another organisation, and we worked collaboratively on both pieces. And I guess my in working on that project exposed me to all of the history, if you like, that MFE had gone through for the earlier proposal for the NPSIB that had been put on hold, and then they'd reinvigorated it for the latest version. So there was probably 2 decades of research and working group material that had gone into why this was important, and I had to synthesise a lot of that literature for that project. So certainly familiar with the principles of why it's needed and the benefits, and how there's a lot of research about the values that communities around the country place on either individual species or individual habitats or ecosystems. And there's research in terms of what it means, everything from New Zealand's brand for exports and the quality of our environment and what that means in economic terms. Also the tourism value, so the value that tourists put on Indigenous biodiversity when they travel around our country. So it was really a synthesis of all of that literature that's it's really uncontested.
Can I just add to that, there's a synopsis of that in the Section 32 that goes with the Eco chapter if you want more detail on that.
It certainly had a long gestation. There would have been a lot of material to work through.
It was significant, yes.
So at your paragraph 23, where you're responding to the point around CIAs and acknowledging that it wasn't a feature of what you incorporated in your costings. But I did pick up that you might have been indicating that the cost could be highly variable, i.e. it could be that you've got this example cost, but it could go.
Yes, so we did have some conversations. I'm not entirely sure how this council has managed those iwi or local inputs in the past. It may be, and it's difficult because this chapter is essentially new in the district plan, so I don't have any direct experience of examples here. It may be that in the past that a council planner has notified local iwi and they've through an email process, for example. Now that input would obviously be significantly less costly than 3,000 and may equate to perhaps council planner hourly rate, perhaps. So I'm just flagging the fact that I'm not sure how that's handled here, and there may be ways that it is achieved at a lower cost. And I believe that there's probably been, even in the hearing last week, some further discussion as to when it might actually apply. So I think there's a few hoops to jump through before one would actually be faced with those costs in the first place.
Just before we move off the cost, at paragraph 21 of your supplementary, you talk about referring back to your evidence in chief, and you identified consent application charges ranging from 1,580 unnotified to 5,000 notified. Was that the full cost or the deposit?
I think that wasn't the full cost, and I think my evidence mentioned that there's further fees through the process that go on top of that.
Yeah.
Yeah.
So, carrying on with the CIA situation, I did pick up as well that you might have been pointing towards, well, you are pointing at your paragraph 24 towards differences associated with scale. And so, where that sits will have a lot to do with scale and significance.
Yes.
And so that would go along the track that you've been pointing to around day-to-day farming activities, the work of the permitted activity, and then it's only when you get into a consenting requirement that this would come up. But even then, it would also be related to the scale of the project concerned as,
Yes, so in farming activity, well, if we're taking farming as an example, and it's not the only use of rural land, but given that we've, I think, determined that most day-to-day activities of farming have been, at least there is scope to address those within the provisions. It's only when an existing activity is greater in scale or character, in terms of its clearance requirements, or if it's a new activity. And again, I would suggest that the incidence of those new activities that will require the clearance will be very low, and apply to relatively few properties in any given year. So most of any consent that's perhaps triggered through a farming activity is likely to be small in scale. Whether that triggers a cultural impact assessment, I'm not sure. But equally at the other end of the scale, if say Transpower's extending the grid, or NZTA is putting through a new road, those are large scale projects which have always, in my experience, been carried out at kind of the gold standard. It's part of their social licence to operate, and they would normally have included that kind of engagement with iwi in any case as part of that process, so those costs would not really be more than they would already be spending.
And I think that what you're saying there around, we're talking about a low number of properties and therefore a low number of potential such activities in any given year, that might speak to also the potential load on local orunanga to respond.
Yes, exactly, and I don't think that that's, if there are very few instances where they need to respond, then perhaps those time delays that were alluded to in that evidence won't exist. If they're not overwhelmed, then that's probably a key factor to take into consideration, and that may keep their costs down.
I think just to follow that up, my understanding is you not only signalled that it's a low number of properties, but on those properties it's a low percentage of coverage typically.
Yes, so the actual reality of needing to clear vegetation under any of these rules is probably very rare. I mean, if you've got a farm that's got even, say, 10% coverage of Indigenous biodiversity and you need to build a new barn, well, you probably weren't going to build that barn in the area covered with Indigenous vegetation in the first place. So a lot of the activities that occur on farms in terms of new structures or even fences or vehicle tracks or building a new dam, water storage area, these things probably, in my mind, we need to consider whether the farmer was ever going to put them in the most difficult place they possibly could, in the forest, in the valley or the gully or on the top of the hill. Probably not. And so I think the practical lens of how often these restricted discretionary or non-complying activities will be triggered is very limited by the time we factor in it's few properties and few practical reasons.
And that is actually the design, is it not, of the rural framework, i.e. it's intended to protect those areas and
Yes.
and incentivise use of land outside those areas.
Exactly, and not to, and as a simple analogy, if a farmer had, before these rules even got raised or the NPSIB came into effect, and let's say they disregarded the RMA, if they said, oh, well, I wanted to put in a new fence, or I want to put a vehicle track in that goes right through the middle of this area of bush. Well, if that had been appropriate 5 years ago, it's not appropriate today, because we now recognise the values of that bush, and so the rules are there to encourage the farmer to put the track around it, not through it, unless there is good reason. And if there's good reason, then there's a consent process to evaluate those reasons. Mm.
At your paragraph 42, where you are talking about the existing width and no net loss, I did wonder if this was also relevant to existing use rights or lawfully established existing use. So that if you've already got some existing width there, understanding that this phrase is being sort of introduced, it did seem to me that it tied in with existing use rights and those not being interfered with through this process.
Yes, absolutely. Both the existing use rights and I guess the not wanting to impose additional costs through a consent process, I guess because of those existing use rights. So the situations where this might apply out with a fence line is that, let's say the fence was put in 20 years ago. At the time, according to the evidence provided, which is helpful from Stony Creek and some others, you know, they've explained the sorts of machinery they would have used, the bulldozers and whatnot that they would have used to build it in the first place. They've obviously cleared a pathway and then they've built a fence down the centre of it. I guess I was trying to allude to the fact that even if you don't need to clear that vegetation along that fence very regularly, but there is some sort of regeneration of plants coming back into that area and you need to drive your ute down there to inspect your fences, that you should, I believe, be able to go back to that original cleared path that you created some time ago, because that's what's, you know, that's no net loss. That's vegetation that was removed, and we drew a line in the sand with the NPSIB, and therefore just taking that away again is no change in terms of that. Doesn't work in every situation, but as Mr. Wells has pointed out with some new evidence, there's so few fences that we think actually go through Indigenous vegetation that, you know, this isn't really a very big issue.
And so at your paragraph 46, where you've left the wording of Eco R1 1A sort of open to further refinement, is there anything else you want to add now, or is that subject to evidence we're yet to hear through the hearing?
I think we're just, obviously the section 42 had a particular wording. I agree that maybe there's a little bit ambiguous as to what it may have meant, and maybe we could refine the wording a little tighter. I think I'd used previously cleared, and another submitter I think had used originally cleared. It's just whether we need these words to make it unambiguous for landowners and readers of the plan.
Of course, previously cleared could be last year, as opposed to originally cleared that was 10 years ago.
Or 100 years ago.
Yeah.
I mean, you know, we run into sort of funny time issues.
I think it needs to apply to perhaps that loan, either previously cleared by that landowner, obviously landowners change, or that there's clear evidence that there was, because you can tell where revegetation, it looks different from the original that has been untouched. So I guess if there's some sort of evidence, I can see that it was back to here, I'm just going to re-clear it down here so I can get my ute through, or you know, something like that. I get it doesn't work in every situation, and there may be some situations where there was, there's just no way of knowing, you know, that it's regenerated so densely that we just can't see it. And maybe there are examples, for example, where the Croydon bush or the dockland, actually the Indigenous vegetation carries through the fence line or through the property boundary and into Hokonui Hills Stony Creek Station. It's a continuous area of vegetation. Now, I don't know, but maybe there's a boundary fence between the dockland and the private land, and maybe that's not something that regularly needs to be maintained. It may need replacing one day, and there would be situations. And so, if there is no cleared area that is obvious, then that would require a consent, because obviously that vegetation may have become, it is significant, it's in a SEVA, and so it's appropriate that a consent is applied in that situation.
So you were alluding then to those visual cues and a sense of regularity.
Yes. A bit like the improved pasture provisions in the NPSIB, and they talk about a regular pattern of clearance for the improved pasture definition. So I guess I was trying to allude to something along those lines.
That's all I had. Thank you.
You're welcome.
Maybe I could just follow up, because there's a distinction between the Hokonui Hills area, which does allow
true.
for maintenance of existing fences, for example, and that's largely because Andrew has done a detailed analysis of the Hokonui Hills area, whereas that detailed analysis hasn't occurred to the same degree for areas outside the Hokonui Hills area, although Andrew has done a preliminary assessment as per his memo that he's circulated. So slightly different approach with different areas based on the level of analysis that's been undertaken. And I think the challenge in Gore, when you're talking about existing clearance, is that prior to this plan there were no limits. So existing use rights was open slather on private land.
And of concern to us is the, I guess, second-hand messages being passed on to us that there are farmers out there at present who are clearing, or landowners, shouldn't just say farmers, landowners are actually clearing indigenous vegetation currently, contrary to these rules that are now in force. So just want to flag that we're aware of that's going on. Also, I should have indicated when we started that sometime between 10:15 and 11:15 we'll take a 12-minute break, and I think now is the logical time to do that. So we'll come back to you after we have a break. So
Sorry, Commissioner.
Yep.
Can I just jump in for 1 minute? Apologies, it's very hard to know when to speak or not speak without interrupting the flow, but I have one comment I'd like to make which picks up on your question to Ms Hampson and a statement that you made at the start of the hearing, if I might do that now.
Sure.
It's in relation to the point of Council supporting landowners to undertake biodiversity assessments, and you'd made an observation regarding committing Council to funding allocations, and I just wanted to address that if I could please. So I would firstly observe that in my experience this type of approach is a common one that is endorsed in other district plans elsewhere to support the objectives of identifying and protecting SNAs, SIVAs, and is of course supported in the NPSIB. It is a prudent response in my submission by a regulator to a tricky issue. You've had evidence in support of this tool, I would observe it may require a budget to be allocated on an annual basis for mapping and assistance, but it doesn't necessarily need to be a significant amount, so it could be a certain amount that's closed once an annual allocation is exhausted. The evidence that you have is that in this district there are a low number of properties that it would apply to and is in smaller areas, so perhaps not a large amount of money with a high degree of value obtained. And I think if you map that out over 10 years, the allocation annually may not need to be a significant amount. Given the regulatory requirements under the RMA and the NPS, I would submit that this is in fact a matter the panel can deal with through its decisions now for the funding to be then allocated later. through an LTP process. And I would submit the budget line is not necessarily as a consequence of your decision, but more as a result of those regulatory obligations under the Act and the MPS. If for any reason, sorry, I'll just go back to one step. So the point at which the decision on funding would be approved would be when the plan is approved to be made operative by council, and there would need to be in my submission a specific line noting the potential need for allocation of funds in the next LTP process to support this at the point, at the level determined appropriate by the council at that time. Perhaps the council could decide to defer if it was a thinner year, or provide a fulsome amount if it was a year where it was anticipated more funds would be available. I would also note that funding is available from elsewhere, regional council, other entities, and if it did happen that funding was not available and the council had decided that over a long period it could not do so, then it would need to also correspondingly make a decision to vary the plan to reflect that position. But at this point, I would say that it is available to this panel to make the decision to include support for that approach.
I did wonder, however, and thank you for that feedback, but I did wonder with the provisions that are in other plans, whether they were there at the time of notification. So when the council actually voted to notify the plan, it was there, whereas this is a new one that's popping up, as it were, as we go through the process. And I guess I go back to my point. We aren't authorised to commit the council to funding. So I hear what you're saying. So thank you for that. So the time is now 10:30. We'll adjourn until 10:45. Thank you.